accused must have had the intention to deceive and defraud the victim. The inducement, the false pretense, must have caused the victim to deliver the goods. And lastly, that the goods obtained must be capable of being stolen. I have put in citation, Director of Public Prosecution versus the Otieno. The accused was charged with falsely pretending they would sell a vehicle, and the court focused on whether the prosecution could prove the false pretense and resulting loss of money. Another authority is Isaac Kimeu Mutuku versus Republic, whereby the appellant was convicted for issuing a bounce check for the purchase of maize, having falsely represented, and he had sufficient funds. And last one is Ruth Wamboi Githinji versus Republic. The appellant was convicted for falsely pretending should facilitate a company's acquisition of operational licenses and permits, and that the money she received was the required fee. Now, the legal precedent and requirements which include the proof beyond reasonable doubt that all ingredients of the offense must be proven beyond a reasonable doubt for a conviction. Past or present fact that the false pretense must be about a past or a present fact, not a future one. I've further cited the Court of Appeal criminal case 320 of 1990, which was in Kisumu, and the same is also intact. Now, having said the above, and in view of the foregoing, now this court finds that the prosecution have proved their case beyond reasonable doubt, and this court finds you, accused person, guilty of the offense herein and convicts you accordingly. Yes?
Yes, the accused person is very remorseful in that the Honorable Court has found her guilty of the offense. The accused person is a single mother, taking care of 4 children. One of them is as young as 3 years and the other one is 7 years. The other one, Your Honor, is doing his internship after graduation, and one of them is in the university. Your Honor, she's the breadwinner of these children. Following the consequence of this particular offense, Your Honor, which were actually, after she was charged, Your Honor, the company was forced to close down because the police took all her files and she could not continue. Your Honor, we are kindly requesting the Honorable Court to consider an non-custodial sentence to give chance to the accused person to take care of her children, Your Honor, who stands to suffer if the accused person was to be given a custodial sentence, as they have no one else to take care of them. And in particular, the girl, Your Honor, in the university, she stands who is in KU in her second year. Your Honor, she might be the only person who may resort now to take care of the children. She starts to lose her education. Also for the minor, particularly those who are 7 and 3 years who are in primary school. In fact, one of them have not even been in school. They also start to suffer, Your Honor, because they start to lose their education. And in the circumstances, Your Honor, we are kindly requesting the Honorable Court to be lenient enough to the accused person and give her a chance to take care of her children, who are innocent, Your Honor, in this particular matter. But they started to suffer by the consequence of the accused person. In the circumstances, we are kindly requesting the Honorable Court to consider an non-custodial sentence.
Now, the accused will pay a fine of 100,000 in default 12 months in custody. The court notes the mitigation. You have a right of appeal 14 days. This judgment is read and delivered in open court this 2nd day of December 2025 at 10:34 East African time. You have a right of appeal 14 days.
We are most obliged.